Hello, I'm Assistant District Attorney Darren Allemand. Among my duties at the Jefferson Parish DA's office, I have the honor and privilege of assisting our District Attorney Paul Connick with putting together our package of legislation every year. In Jefferson Parish, we have been blessed with many resources, and because we believe that those blessed with much have an obligation to work that much harder to give back to our communities, we are very active each year in putting forth legislation to improve our criminal justice system. One bill I would like to talk to you about today is Senate Bill 186, which became Act 104 when our governor signed it into law. This bill, which is a joint endeavor between our office and Innocence Project New Orleans, creates a pathway to relief for defendants who prove that they are factually innocent of the crimes for which they were convicted. We're all blessed to live in this great country, but while the American criminal justice system is the best in the world, it's not perfect, and that's simply because it happens to be staffed by fallible human beings. One of the many reasons why I am so proud to serve the people of Jefferson Parish as a prosecutor is summed up by what the Louisiana Supreme Court said in the 1936 case of State versus Tate. It is as much the duty of the district attorney to see that no innocent man suffers as it is to see that no guilty man escapes. Louisiana law provides for something called post-conviction relief, which is a mechanism for defendants to raise claims challenging their convictions under certain conditions after the conclusion of their appeal. Louisiana law, until now, only expressly provided for defendants to raise factual innocence claims on post-conviction relief using DNA evidence. This left out other types of reliable evidence, such as, just for one example, fingerprints. Now, to be sure, we prosecutors did not take that to mean that someone who is truly innocent but has evidence other than DNA is out of luck. Certainly not. When confronted with someone who was truly and demonstrably innocent, we would work something out to get that person freed. But we felt that there needed to be an actual law on the books with actual guidance for prosecutors, for defense counsel, and for judges. Obviously, the imprisonment of anyone who is innocent is a travesty of justice and should be remedied no matter what. However, it's also a travesty of justice for defendants to litigate frivolous claims and further traumatize victims. So this bill set out parameters for what needs to be shown to successfully claim factual innocence. It allows a defendant who has been convicted of a crime to establish his innocence in a post-conviction relief proceeding using reliable evidence other than DNA that meets certain listed criteria. One of the criteria is that the evidence has to be scientific, physical, forensic, or non-testimonial documentary evidence, or testimonial evidence that is corroborated by that type of evidence. The bill also allows for post-conviction plea agreements. This is helpful in making sure that justice is done in situations where, say, the defendant is guilty, but where maybe there's a different interest of justice concern with the case. For example, this would provide a mechanism to revisit an excessively long sentence for someone who has no violence in his or her background. This just gives us more flexibility to carry out our mission to ensure that justice is done. We would like to thank all of the hardworking men and women in our legislature. Special thanks go out to Senator Gary Smith Jr. for putting forth this bill for us, and to Representative Marcus Bryant for his assistance when this bill reached the House of Representatives. Thank you for watching, and we are all honored to serve you.